Hello, all. Have you ever wondered as to why we protect the environment? Whether an animal can file a case against you in court? Whether a river could take you to court if you were to pollute it? It, of course, is no secret that we protect the environment for our own sake, human sake. But is that all? Should we not be protecting the environment for its own sake? Is that not what is expected? Or am I wrong? Well, that's exactly why I'm here and what I would be discussing with you. Of course, from an Indian perspective. The Indian experience is at a very nascent stage and surely does have a lot to learn about the rights of nature movement and imbibe the true spirit of such a right. When did we become independent? Yes, in 1947. We enacted our constitution in 1949. If we were to delve into it, you would notice that Article 21 conveys one of the most important rights. Does anyone know what it states? Well, it speaks about the protection of life and personal liberty. It lays down that no person shall be deprived of his life or personal liberty except according to procedure established by law. After taking part in the Stockholm Conference of 1972, do you know what dawned upon us? Legislators, they realized that changes need be brought about in the Constitution. Why? The Indian Constitution did not have any express provision relating to environment protection. Now, what do you think was the outcome? The 42nd Constitutional Amendment was brought about in 1976 and added two articles intended to protect the environment. Article 48, capital A, the directive principles of state policy, duty of the state, and Article 51, capital A, G, a fundamental duty imposed on the citizen. But there was a problem. Do you know what it is? Both these are not enforceable by courts, which means that if they are not followed, no action can be raised before the courts. Well, to get over this, courts had to figure out a way, and this started off with the RLEK case, wherein the Supreme Court gave a liberal interpretation to Article 21. The right to life was interpreted as not mere animal existence, but one wherein all those facets that an individual should enjoy should be present. A meaningful, complete, dignified life. Well, it was soon just a matter of time. The Supreme Court in Subhash Kumar versus State of Bihar held that, well, we do have a right to live in a healthy environment under Article 21. Similarly, a number of other rights too were read under Article 21, and this became a repository of rights. In T.N. Godavarman Thirumalpad versus the Union of India, the Supreme Court opined that environmental justice could be achieved only if we were to drift away from the principle of anthropocentric to ecocentric, while holding that rivers should be treated as goddesses. Time and again, one notices that the Supreme Court has highlighted the socio-cultural importance that protecting the environment does imply, be it Tarun Bharat Sangh versus Union of India, where illegal mining activity in a tiger reserve was a folk question, or Sachidananda Pandey versus West Bengal, wherein the judge quoted the retort of a wise Indian chief when the great white chief, the leader of the US, asked for his land. All these ideals have been sought to be incorporated into law, and obviously was strengthened when it was opined that ample publicity need be given for the socio-cultural aspects of environmental protection. Do you know in which case this opinion was given? Yes, the 1992 MC Mehta versus Union of India case. Now, this leads us to another question. Does ancient philosophy have anything to do with environmental protection? What do you think? The ethos in philosophy, which serve as a beacon light for Indian environmental law, has been in vogue for many a century. Embellished with numerous traditions and customs, often pointed out by judges, these have been the very basis of the law. Religion and religious practices were said to lay down the basis of a value-based survival of mankind by the Supreme Court way back in 2002 in Aruna Roy versus Union of India. A number of instances can be attributed to many a community in India which follow an eco-centric approach and imbibe their traditional ecological knowledge, which contributes immensely to natural resource management. Have you heard about the Niyamgiri case? Well, mining activities were being conducted on a mountain, referred to as the Niyam Raja, revered by local communities, and the court brought it to a halt. This opened new doors. We also have the decision rendered by the Supreme Court in AWBI versus A. Nagaraja, which stressed upon the importance of providing animals rights. Are you aware of any instances of participatory environmental governance? Well, the National Green Tribunal specifically set up to look into environmental cases wherein you had judges as well as expert members who were usually scientists or administrators. One panchayats specialized local bodies for managing community forests. Pani panchayats specialized local bodies which dealt with water conservation. Ideas of joint forestry management. Community participation in EIA process. Biodiversity management communities which put across local involvement. But one can, with conviction, say that the decision rendered in the Mohammed Salim case opened up a new chapter in providing entities rights. The Ganga and the Yamuna rivers were provided legal status. A new chapter in environmental jurisprudence which stressed on ecocentrism. Any harm caused to these entities was to be treated akin to harm caused to humans. Just think about the emerging jurisprudence. Soon, in the Lalit Miglani case, legal status was afforded to glaciers, including the Gangotri and the Yamunotri, rivers, streams, lakes, meadows, jungles, wetlands, waterfalls. All these were to be treated as legal persons. However, things took a different turn in the state of Uttarakhand versus Mohammed Salim and others, wherein citing administrative problems, the Supreme Court stayed the order of the Uttarakhand High Court. The High Court decision had mentioned certain state authorities as guardians of the river. But do you know what the state did? It was argued before the Supreme Court that since the rivers flowed through many states in India, the state officials can't exercise this duty. However, things have changed for the good in later decisions. In Narayan Dutt Bhatt versus Union of India and others, the same judge, Justice Rajiv Sharma, held that the entire animal kingdom, including avian and aquatic species, need be treated as legal entities, and cast a duty on the citizens of the state to act as loco parentis for their welfare and protection. This was a case which highlighted the sad plight of horses which had to draw carts between India and Nepal. In the Karnail Singh case as well, the same ratio was put forth. In Suamoto versus Chandigarh administration, where a case was taken up as a result of a letter that was sent by a public spirited person, which highlighted the pitiable condition of the lake, the Sukna lake, and the failure of the administration, the Punjab and Haryana High Court held that the government had a duty, and so does a court as well, to protect the environment. The court held that this particular lake is a legal entity, a legal person. It has a distinct persona with corresponding rights, duties, and liabilities of a living person. One cannot but help recall that even Christopher Stone had asserted that whenever a new entity is provided rights, it's met with either ridicule or fear. Breaking free from this set order might be a difficult task, but not impossible. The Supreme Court has an opportunity to delve into the matter as a public interest litigation has been filed by an NGO, the People's Charity Organization, to declare the entire animal kingdom, including avian and aquatic species, as legal entities having rights akin to a living person. The court has sought the centre's response. However, what need garner attention is that the court had opined orally that it is very unlikely that the prayer will be entertained. Given that this does validate Stone's observation of rights to any new entity being met with ridicule or fear, one needs to figure out a way to circumvent the difficulty. Open up new possibilities and get rid of cliches so that the Indian Supreme Court charts a new path. Whatever be the path that is being chosen, one can only wait and hope that the court takes due cognizance of the many developments that are on worldwide and open a new chapter in environmental law, a purely eco-centric approach where humans are one among various components of nature. Don't you wish that this happens as soon as possible? Well, I do. I hope you would have by now understood a different approach to environmental law. Thank you.